All right. So with respect to next week, group presentations, I've heard from three groups who have told me that they are either going to do their presentations live in this time frame next week, or we'll be providing a pre-recorded YouTube video for presentation, which is perfectly fine. So I'm still waiting to hear from the other three groups. So hopefully I hear in the next few days so I can get everything organized for next week's class. Everybody will be given a score sheet next week so that you will be scoring, as will I, the presentations of your classmates, basically. And you will be getting additional participation points for, in fact, providing those score sheets to me. So there's a reward, obviously, for doing that. With respect to the final papers and final exams, your final papers are due on Friday, the 23rd, so a week this Friday. So if you're giving me a paper, please get it into me by then. And again, the final exam is in this time frame, 2 weeks from tonight, so 7 o'clock on April 26th. Any questions about that? Are we good? All right. Okay. So what we're going to do tonight, to begin with, is we're going to have a discussion on the documentary I posted for you on Moodle. It's a CBC Fifth Estate documentary called "A Death in the Family." It's the story of William Mullins Johnson. So obviously, those of you who watch this will know that he is an Indigenous man from Sault Ste. Marie. So I show this video all the time because I teach a lot of criminal justice courses. I teach courses on Indigenous criminal justice, on wrongful convictions, and on sentencing and all kind, everything that I teach relative to criminal justice, I include this video in it because it's a very powerful video. It tells you how the justice system can go wrong and how an innocent man can spend 12 years in federal custody, totally for something that was not his fault. And it also gives you the connection to Sault Ste. Marie. Sault Ste. Marie, and I mentioned this earlier, is actually a fairly central point for a lot of things that happen in the Indigenous world. We've already examined in the first part of the semester the case of Stephen Powley, who was the gentleman, Indigenous gentleman, who shot the moose and left his name on a tag attached to the moose's ear, basically saying that I've shot this moose. I'm coming back to get him. My name is Stephen Powley. He did it with his son. And then he was charged with shooting a moose out of season and without a tag. And it went all the way to the Supreme Court of Canada in 1993. And basically it established the very definition of who can qualify to be Métis and have rights of Indigenous persons in Canada as a function of that identity. Right. There are other cases that aren't quite as well known. I acted for a gentleman when I first came here to Algoma, when I was still connected with the Ottawa Innocence Project. It was a guy from Sault Ste. Marie who was convicted in the 1980s for what used to be called constructive murder, which was essentially if you were with the people who committed a crime, including murder back at that particular time, even if you weren't actually there at the place of the murder, you had nothing to do with the murder or the homicide, but as a function of being connected to the people who were, there was a provision in the criminal code that in fact would allow you to be convicted of that particular crime. And he was. And what happened, however, was he was convicted of second-degree murder, so that included a minimum of 10 years without eligibility for parole. And what happened is just near the end of when he was finishing his imprisonment, the Supreme Court of Canada struck down that provision in the criminal code, basically saying that you cannot be convicted of a crime as serious as homicide unless you were actually involved in it. So the constructive nature of the elements of the crime were eliminated, and he, has been fighting ever since his release from prison. So from 1987, 88 to like now, so 40 odd years, almost 40 odd years, 35 years later, he is still trying to clear his name because he quite sincerely believes that he never should have been convicted of a murder to which he had nothing to do with, other than actually being in the company of the two guys that did the murder that particular morning. And he's been unfortunately totally unsuccessful in getting his conviction overturned. which means, and this is really important to keep in mind, when you are convicted of first degree or second degree murder, it is a life imprisonment sentence. So even though you will be, and you would all know this, in first degree murder, even though you are ineligible for parole for at least 25 years, right? That's a mandatory minimum sentence for murder. Uh, Even if you're released after that 25-year period of time, you are still subject to life imprisonment, which means for the rest of your natural life, you will still have to report to a parole officer, even though you've done your 25 years in prison, or in his case, 10 years for second degree murder. And so from 1987 to 88 to this day, he still has to report to a parole officer. He will never get out from under that obligation, right? And hence, obviously, his pursuit of getting his name cleared, and unfortunately, that hasn't happened. Okay, so having said all that, let's go back to a death in the family, the William Mullins Johnson case. So, anybody have any comments about what you've seen? Elizabeth?
So I think that this is a perfect example of like the police zoning in on one particular person for a crime, even if the facts don't necessarily point in their direction, and kind of running with it. And in this case, because of the fact that he was Indigenous, I think this kind of shows the systemic problem that there is of like the overrepresentation of them. Because if there is ever a situation where an Indigenous person is called into question for a crime, they automatically assume that they're guilty, whether or not the facts actually show it. So like the two doctors that were their opinions were kind of called into question. I think it was Dr. Smith and Dr. Rosaya. That just proves like confirmation bias, that they were kind of only looking for things that supported their theory, and anything else that would actually have proved Mullen Johnson's innocence, they kind of ignored.
Absolutely true. And that's called tunnel vision. And we're going to be talking about that tonight as part of the course. I can tell you that Rupinder Risaya is actually still in Sault Ste. Marie. I actually saw him at a Canadian Tire. I think it was last year, the year before. And he's the one you guys would have remembered. He's a pathologist who, at the end of the documentary, still denied any culpability for what he did, right? He basically still said, I don't care what the other 5 international experts said. William Mullins Johnson is guilty based on that. And unfortunately, that's the kind of attitude you tend to get all the time, even after wrongful convictions are proved in fact to be wrongful. Michelle?
I was just going to say, sir, I just don't understand in that sort of case, why another pathologist at that time, like, why didn't they get a second and a third opinion? And, I think that this, in my opinion, goes towards defending the police because, like the police fumbled their investigation as far as I'm concerned in that case. And so did the science in this case. The pathologist had the science facts in front of him and he just does his job, right? And somewhere along the way, an innocent person lost 10 years of his life for something, and his whole family. Like, he's never going to regain the trust of his family after something like that. So,
Yeah,
the poor guy, he's just lost everything. And I don't think that he's been the same ever since. He was in the news a couple of years ago saying that, he was still fighting for, and he'll never get back what he lost because his brother, as you saw in the video, his brother's still upset about it, and same with the nieces and nephews. So how do you regain that trust? You can never repair the damage that science and the police have done in this instance, as far as I'm concerned.
no, that's true. I mean, these kind of things follow you forever. I can tell you, that a couple of things, because I know Bill Johnson. So he has reconciled with his niece and nephew. His niece was more upset than the nephew. So even though it didn't look like, and that documentary was made about 2009, 2010. So he has reconciled with the niece. So that's a good thing. The Ontario government paid him $4.25 million. That's called an ex gratia payment. It's under the federal, provincial, territorial guidelines for compensation. So, he did get a fair amount of cash. He still struggles with, no, I actually haven't talked to him in a year or two now, but he was struggling up until the last time I had any contact with drug and alcohol problems, right? And so those things those things just didn't go away. But you know, it's almost always the case. No matter how much you get paid at the end of the day, it never replaces, in his case, 12 years of being in prison. Right? That's something that he'll never regain, no matter how much money he gets. Any other thoughts or comments? Any other hands? Okay. Well, I'm surprised only because this is such a great video. I thought we get lots of comments on it, but if you don't have any comments, that's okay. We good then? All right, guys. All right, thank you for that. Okay, so we're going to move to the lecture. So let me just share my screen, and it's going to be our class tonight is on Indigenous peoples and the criminal justice system. All right, and so this is a broad topic. We're only doing one class on it in this particular course. I teach an entire course on Indigenous criminal justice. There's also make sure everybody gets into the class here. There's also a course on wrongful convictions that I teach. I do a lot of this in a course called the Institutions of the Criminal Justice System. So it's an incredibly important issue, right? And Indigenous peoples in the criminal justice system is something that draws a lot of attention because it has gone wrong for such a long period of time. And going back to what Elizabeth was saying at the very beginning, the first and most obvious issue with Indigenous peoples and criminal justice is their overrepresentation in that process, the criminal justice process. Now, this slide is a couple of years old, so these numbers are updated a bit. So Aboriginal Indigenous peoples are now between 5 and 6% of the population. And again, that's a function, you guys would all recognize that, of the Daniels decision in the Supreme Court in 2014, because it added about 600,000 Métis to the constitutional definition of Indigenous persons. So that number has gone up. So Indigenous people in Canada are 5 to 6 of the population. They account for about 23% now of federally sentenced offenders. Who can tell us, what's the difference between, and I think we've done this before, what's the difference between being sentenced to a federal penitentiary and being sentenced to a provincial jail? Anybody? Okay, hang on a sec here. Michelle?
Provincial jail is 2 years less a day, and federal prison is for 2 if you get, say, killing people, assaults, things like that, anything over 2 years.
Karina, same thing? Yes, no?
Yeah, I was going to say the same thing.
Okay, yep, good. Yeah, exactly right. So if you're sentenced to 2 years less a day, right, under 2 years, you're going to go to a provincial jail, and which could be, there is a provincial jail in Sault Ste. Marie. It's on Great Northern, just past the OPP station, right, near the hospital, right? So they have a jail there. It holds about 140 or 50 inmates. About 110 or 20 are men, 30 or 40 are women. It's fundamentally a remand center, but if you are sentenced to a short period of time, less than 60 days, essentially, and that's the vast majority of sentences for jail time, you'll do it there. They won't ship you off to one of the super jails in Ontario. Super jails in Ontario have. Oh, is there a problem with audio, guys? You guys good? I have a message here. Is there everybody here? Is there an echo on what I'm saying? Okay, well, let's keep. Not when I speak. Okay, all right. Hopefully we're okay. Sorry, guys. Okay, okay. So yeah, so super jails. There's 3 of them in Ontario. So having said that, if you are doing any more than 60 or 90 days in a local jail, which is what is in the Soo, they're called buckets. That's what they call them, local buckets. If you're doing more than that, you'll be sent off to one of the super jails, which is going to be in Toronto, has a super jail. Lindsay, Ontario has a super jail. That's about an hour and a half to the northwest of Toronto. Or Penetanguishene, which is on Georgian Bay, about an hour and a half to, sorry, Lindsay's the northeast, Penetanguishene is the northwest. They hold between 11 and 1,500 inmates, and that's why they're super jails. So that's where you tend to go if you have any period of time more than 60 or 90 days. If you're going to a penitentiary, all right, so you're going to first, they used to go to Kingston Pen, as in the original Kingston Penitentiary, the first penitentiary in Canada. It's closed now. It has been for about 10 years. You will now go to one of the other federal pens in the Kingston area. There's like 8 or 9 of them. I'm not too sure which is the intake one right now, but you're going to go there and you'll be there for 2 or 3 months. They'll assess your rating, as in, as in from the least serious to the most serious kind of thing, maximum security, minimum security, medium security, and then they will ship you out to a penitentiary across the country. You really have no choice in where you're going, which is really hard if you think about it, because if you were, say you were doing less than 60 days in Sault Ste. Marie, because it could be an impaired second charge, that kind of thing, you're going to be in the same town where your family is. So hopefully your wife, husband, girlfriend, boyfriend, children, whoever they are going to be, or parents, will come and see you, right? And that's a really big deal when you're in jail. If you're in a penitentiary and you committed your crime in Ontario, and they ship you to Stony Mountain outside of Winnipeg, or anywhere else in the country, going from British Columbia to Newfoundland, you're not going to see your family, right? So those are kind of things that are very difficult to deal with, and that's what's going to happen if you get sentenced for a crime of 2 years or more. So over about 23% of all federal inmates are Aboriginal or Indigenous, right? Which is 4 times the population proportion. If you're a woman, it's 33% in custody. And provincially, for representation, if you are in any of the prairie provinces, Manitoba, Saskatchewan, Alberta, British Columbia, over 50% of the provincial population in jails is Indigenous, right? That's a gross overrepresentation. So that gives you a pretty good idea of how ill-treated Indigenous offenders are for the most part. There are several ways that the criminal justice system is defined as discriminating against Indigenous peoples. Number one, an Aboriginal accused person is more likely to be denied bail in a case, and that's incredibly important, because if you don't get bail, and which means you spend the time between your charge and your trial in custody, it makes it very difficult for you to instruct your lawyer, right? You have to count on your lawyer getting to whatever jail you're in to get instructions, right? And they don't have Zoom, they don't have FaceTime, they don't have Skype, they don't allow any of those kind of things to communicate with not only your lawyer, but your family, although there is some talk about that kind of thing, right? And it really makes sense why there wouldn't be, but it's not in place at this point. Aboriginal people spend more time in remand custody. Anybody know what remand custody is? Okay, well, remand custody is custody that you're in jail waiting for something to happen. So you're arrested, you're waiting for your bail hearing, or you're arrested and you get a bail hearing and you don't get bail and you're waiting for trial, or you actually go to trial and you're waiting for sentencing, right? All those are called remand custody situations, because you're remanded there until something else happens. Okay, that's the way that works. And 3, Aboriginal accused are more likely to be charged with multiple offenses, and that's just a function of how the police treat Indigenous accused. All right, this discrimination has become systemic. We know what that means. It means it's built into the system, right? So police use race as indicators for patrols, arrests, and detentions. Okay, and this is widely known. For example, police in cities, particularly cities that have a large Indigenous population, like Winnipeg. Winnipeg is the most densely Indigenous populated city in the country. The police will tend to patrol bars and streets where they'll find Indigenous peoples congregating, rather than locations where, in fact, there's clubs or bars that are fundamentally white, right, or non-Indigenous, right? And that still obviously happens, unfortunately. So that's certainly a systemic indication of discrimination, right? And police see the world, and this is a very broad statement, and it is still fundamentally true. Police see the world in terms of black and white, right and wrong, right? It's called the blue wall. So the population, for purposes of how police view the world, is, we are right, we protect society, and everybody else, who in any way whatsoever has ever been in trouble, are trouble, right, and will be treated as such. And then unfortunately, as you see, as a function of the overrepresentation, that includes a lot of Indigenous peoples, right? The only time that this is really, that the blue wall has really come down, and this is obviously really recent, and you guys will recognize this. So who recognizes this photo? Who knows, what is this a photo of? Every one of you should recognize this. All right, Elizabeth's in the chat. That's, I prefer you say it out loud, Elizabeth. I get to it sooner, but yes, that's George Floyd, right? So good for you. What's the cop's name? And this is why it's important in the news these days. Anybody know the name of the cop who has his knee on George Floyd's neck? All right, Shannon. Okay, thank you. Yeah, Derek Chauvin. Absolutely correct. Right, and so if you're paying attention to the news, he's on trial like right now for the murder of George Floyd. He was charged with first-degree murder. His trial started about 10 days ago. The 3 other officers that were with him that facilitated that arrest have all been charged with accessory to murder. Right, so it's but Derek Chauvin is the one that all the attention is being focused upon. And the reason I say that this is this is an exceptional example of where the blue wall doesn't take effect is that at the trial, and right now as the prosecution is still putting in their case, the prosecution has been calling a number of police officers in the Minneapolis police force, right, which is where this took place. There was a shooting in Minneapolis today as well. I won't want to get into that. It's all part of this. It's god awful. But having said that, during this trial, the chief of police of the Minneapolis police force came to trial in his full uniform to basically testify that what Derek Chauvin is doing in that photograph is not something that he was taught to do, is not within the scope of what police should do. He's acting totally outside police approved activity. And there's all kinds of other police persons testifying to the same effect. That virtually never happens when a police officer is charged with harming, a accused person, particularly a Black person. Matter of fact, this is the first time, at least what I read this week, this is the first time that has happened in the United States of America, where the blue wall has come down and where the same officers in the same police service as the accused, Derek Chauvin, are taking the stand against him. That just does not happen. What almost always happens, right, and it will still happen in the future, is that if an officer is accused of a crime, what usually happens is that the members of the same police force or service, most of the states are still police forces, they will come and sit in the body of the court, in the seats watching, the court, in full uniform in support of the officer. And they do that to intimidate the jury. They want the jury to know that it's one of their own who is on trial, and he or she, almost always men, but he or she, has the full support of the police force, right? So the fact that the chief of police of the Minneapolis police force came, it would have been the end of last week, and testified against Derek Chauvin, is the first time in America that the blue wall has come down, right? So that's really important. But keep that in mind, because that is the kind of mentality that applies everywhere for police forces, including Canada, right? And it's the kind of mentality that Aboriginal accused face when they have to deal with the police, right? Indigenous people are at the bottom of every index with respect to the following, and this is obviously a culmination of what you guys have learned over this semester: educational levels, employment opportunities, housing conditions, per capita incomes. We all talked about that when we talked about the socioeconomic conditions of Indigenous peoples, basically. And because of that, they become a self-fulfilling prophecy, because if an Indigenous person is charged with a crime and they're seeking bail, right? In order to be granted bail, they have to show that in fact they're employed. They have to have a fixed address. They have to show either they're working or going to school and have strong links with the community. All of those things are lacking in a great number of cases. And that's why, there are far more Indigenous people, in remand custody waiting for bail or being denied bail than non-Indigenous peoples, because these conditions feed into the denial of bail. All right. Okay, now let's deal with issues that are very particular to Indigenous accused. So let's deal firstly with sentencing, firstly restorative justice, and then we're going to deal with something called the Gladue principles. All right. So restorative justice is a significant process that's been involved in criminal justice circles in Canada for the last 20 odd years. It's an attempt to downscale the Western style criminal justice system that has existed in Canada since Canada had courts, right? And you all know, as a function of the British North America Act in 1867, that we adopted the laws of England at the time, which were already in place prior to Confederation as a function of it being a British colony. So obviously they're applying their own laws. And then Canada, when it became an independent nation in 1867, still carried on English law, right? And that English law is an adversarial system, particularly with respect to criminal justice. So what restorative justice is it is a way to divert the process away from that adversarial zero-sum game. Okay, so to take it away from what has developed in the common law jurisdictions of Western legal systems. So it's essentially a mediated process that offers a face-to-face discussion, and this is really important, directly between the victim and the offender. So an outcome can be negotiated beyond the kinds of sentences that take place in the normal criminal court process. And remember, in the normal criminal court process, the Western style English common law system that we have, victims have a very small role to play. They don't ever come into contact with the accused directly. And for the most part, their most active participation is after a conviction, where they can provide what's called a victim impact statement that goes to sentencing. All right, so this is, restorative justice is a much more direct approach than that is. So what the process does is it addresses the harm to the victims, it holds the offenders accountable for their actions, and importantly, it engages the community, the Indigenous community mostly, in the conflict resolution process. Right. So what it does for the offender, the person who is facing the charges and a conviction, is it basically tells that person that they have to accept responsibility for their actions. Right. They have to recognize the harm they've caused to the victims. Right. And it means they have to look at the issues that can possibly contribute to them committing harm in the future. As in, if we address those issues in a restorative sentencing kind of way, we can hopefully take that offender out of the pattern of continuous harmful behavior. Right. And it's also incredibly important that what this is intended to do is to reintegrate offenders back into the community as viable members of society. And while sentencing as a whole, that's the overall goal of all sentencing, restorative justice is a much more straightforward way to do that. Right. So restorative justice emphasizes relationships, which runs counter to what Western justice does. Adversarial system in Western society is what's called event-based. It means that the criminal justice process revolves around an event, i.e. a crime taking place. The accused is found guilty or not guilty of that crime, is sentenced for that crime, and that is, that encapsulates the process, right? That's how we deal with it in a non-Indigenous setting. Restorative justice, on the other hand, is relationship-based, not event-based, and it deals with the values of individuals and how they're affected by conflict. So, but remember, it's not a value-free process. It's not, it's if an accused is given the opportunity to take part in a restorative justice process, it's not a get-out-of-jail-free card, right? It's not something where they're going to be treated, in a less serious manner than they would be in the normal adversarial process. There is a strong element of denunciation of their behavior. So that's important to keep that in mind. But as important as that is, restorative justice gives a voice to the victims, and the victims actually have a role to play in the resolution of the charge, which again does not take place in the Western society. So the important part about this is that in the Western society, event-based adversarial process, the accused is looked at as an outsider. What's an outsider? Anybody? It's a fairly common sociological term. Okay, nobody? An outsider? Well, an outsider is what you would think it is. An outsider is somebody who is, there's a chat, so hang on a sec. An outcast, that's from Jacob. Thanks, Jacob. Yeah, so yeah, an outsider is somebody who is out of your community group. Okay, that's pretty easy to understand, right? And an outsider who is deviant, as in somebody who commits a crime, it's easy to think of them as being punished, and if in most parts being separated from the community, as in put in jail. Right? So, that's not a hard concept to grab onto. If it's an outsider who's already not part of us anymore anyway, then let's put them in jail. We don't care. We won't see them. We don't care about them. They'll do their time in a totally, outside institution to which we don't really have any care about, right? Restorative justice, on the other hand, is the converse of that. It's where the offender is an integral part of the community, right? And the whole process is to keep that offender within the community, not an outsider, but somebody inside the community, one of us, not one of them, one of us, right? So that the community remains whole. That's really important to remember, right? And that leads to what in restorative justice is referred to in Indigenous terms is a healing circle or a sentencing circle. And that's the core of Aboriginal restorative justice. So what the circle does is it involves members of the community, including the offender, elders, okay, usually the victim and other parties that agree to participate in this circle. The framework of the circle is exactly what it sounds like. Everybody, and this could take place, anywhere. It could take place in a courtroom on the floor of the courtroom, but more often than not, it's going to take place in a separate room, like like a hall, in a community center or something that is more conducive to creating a circle. But everybody sits in a circle facing each other, right? And the theory for that is quite clear, is that everybody's facing each other, which means that everybody has an equal status in the circle. Nobody is above them. So you remember we showed this earlier, in a normal courtroom, a Western style courtroom, the judge is on a dais up at the front of the room, right? Elevated above everybody. And that is to show the authority of the judge and the judge's ability to make rulings over everybody. Well, that's not what a circle does. Now, judges actually can take place in healing circles, and they often do, but they sit down in the circle with no more priority than anybody else, right? And their opinion is no more important than anybody else's in a healing circle, right? In order for the circle to take place, there must be a consensus as to what is to be done by the offender, right? Which means, and that the offender accepts responsibility for the crime. So if everybody doesn't agree why they're there in the circle, right, then it's not going to work. So that, it involves a great deal of consensus. And if they don't have that consensus going into it, then it's just going to revert to the normal sentencing process in the Western society, which is the judge passing sentence on their own. So these are the things that have to be involved in a sentencing circle. The accused must agree to participate, right? So, under no circumstances can one of these opportunities be imposed upon an accused. They have to agree to it. The accused must have deep roots in the community for which participants are drawn, which tends to mean they have to have connections, if they're, to a First Nation, right? Or the Métis community. All right, it's really important because you're gonna want to bring in elders from that community to participate in the circle. So there's a problem with this, however, and keep this in mind. If you are a young Indigenous man in a gang in the city of Winnipeg, you don't have any connections with your elders any longer. You don't have any connections with the First Nation. Matter of fact, you probably don't even want to talk to anybody in the First Nation, including your family anymore, because your family is now the gang. And there's some very large, dangerous gangs in Winnipeg. So a sentencing circle will not work for an accused who has so totally disassociated themselves from their Indigenous life, that it doesn't mean anything to them anymore. Elders will come to the circle, which are going to be either elders or respected community leaders willing to participate in the circle. Again, this is totally voluntary. The victim needs to be willing to participate, right, and has not been subjected to coercion or pressure in participating. And what this basically means is that if, for instance, the accused is facing a domestic violence charge and a conviction for that, they can't be, pressuring the spouse to participate in this. So hopefully they get a lesser sentence. That's just not the purpose of a healing circle, right? If that is the case, where in fact it is domestic violence and the spouse has been subjected to battered women's syndrome, then she will have the availability of counseling and a support team to participate in the circle if she is on her own volition prepared to take place in that circle. All right. Disputed facts have to be resolved prior to the circle meeting. So this is not an opportunity for the accused to retry his or her case again. Right? This is because it's a sentencing circle. There has been a conviction already. So the person who is the offender doesn't say, well, I really shouldn't have been found guilty. I'm not guilty, and here's why. That is not the place for a sentencing circle. This is where the offender takes responsibility for what they've done. They accept the fact they've been found guilty, and now they're going to deal with this as a sentencing process. Okay, here is a 4 or 5 minute video on reconciliation through restorative justice.
Jamie is a young person who found himself in conflict with the law after an incident occurred between him and a social worker.
He was trying to get me away from the door, and that's where I got my bruises on my arms.
Can you guys hear that?
Yes.
Can you? Okay, good. Yeah, I'm having trouble with it, but if you can, that's great.
And because he kept pushing me against the filing cabinet. When I got to the office, I was just shaking. I didn't realize how much bruising there was and everything. And it was at that point my supervisor said, well, you're going to have to charge him.
The Crown attorney felt that the young person would benefit from a Healing to Wellness Court program. In Jamie's particular case, he had a lot of supports, and he personally felt that he was at risk of losing those supports if he didn't acknowledge the harm that was caused. And restorative justice was felt to be the most appropriate way to amend those relationships, to offer Jamie the opportunity to discuss how he felt and perhaps why he behaved the way he did. It was the most culturally appropriate and culturally sound way to deal with this justice matter.
The first time I met him, we're talking about a youth that had struggles in his life and going through so much, and he was pretty angry. And I do an assessment with them so that I understand more about what it is that they need, and then I make the call on who will be a part of that circle.
Restorative justice offers the community the ability to give input and to reshape relationships, and provides a space to do that where there is equality amongst all of the participants.
Jamie was a little nervous, I guess, because I think this was like being able to confront the person that he had done harm with. Because it was a person that he knew very well. I'm going to do the first round. And the first round, we're just going to say our name, what it is that we're here for, what we do, and pass the feather around. So I'm going to start. My name is Yolanda.
I was being put into a different foster home, which I did not like. It wasn't really my decision, really. I either had to go there or that's pretty much my only choice. I guess my foster mom at the time needed a break from me, and I didn't really like that. So I was saying stuff like what I felt and what things that I was going through and apologizing, that I'm just sorry and then it won't happen again. And that I'm got better, that I'm the new Jamie.
When he apologized, it was a welcome surprise for me to hear it, yeah. But me and his foster mom started crying at that point because she's never heard it too, so it was really good to hear from him. I was glad I was able to tell him that I loved and cared about him, and that I was hoping that we would be able to repair our relationship again and start working on goals for him, not just for me, but goals for a better future for him.
I think it's important that we stand behind Jamie and listen to him and continue to have open ears to how he's feeling and what he feels he needs to do to move forward.
It's a healing he's going through now, so to be adult and continue to, get ready for his next step of life.
He liked building. He wanted to know how to make a drum, and that was one of the recommendations that was put in place.
How do you feel about what he has shared with us today?
Accept his apology. He spoke of his difficulties in changing some of his behavior. I was able to see him in a different light and look at him at what he was going through, because he never told me before. It was a good healing process. Yeah, it ended up including the foster parent too, so which is good.
I felt that it was very necessary for me to be in that circle because I knew that after everything was said and done that I've got a second chance and then that I could keep going.
When we're able to go around in circle and hug each other or, shake hands and whatnot, then you know that everybody's feeling good leaving here, and that for them to be able to make amends like that, to me, that's already progress, to open up that communication, to open up that understanding, to open up that relationship again. I think I couldn't ask for anything more.
All right, guys. All right, so I'm glad you could see that. So, okay, we're going to move on. So now we're moving into what's called GLADU and sentencing principles. And this is incredibly important. You can't deal in any respect with respect to Indigenous criminal justice without referring to GLADU, which is a reference to a Supreme Court of Canada decision involving Cindy GLADU, who was convicted of second-degree murder of her boyfriend in the 1990s. And we get around to that decision with a few years prior with respect to amendments to the Criminal Code of Canada in 1996 by what was then the Jean Chrétien Liberal Party of Canada. And this was a significant overhaul to the criminal code. What it did is it brought together from the common law and other sources, all of the sentencing principles that have been practiced in Canada since the first criminal code was put in place in 1892. So it put into place what became a section of the criminal code dedicated just to sentencing. And as a function of that, this particular provision was put into place, and this is section 718.2E, which deals with the actual sanctions that should be imposed in a sentence. And this isn't dealing with a restorative process. This is clearly a normal sentencing in a normal Canadian courtroom dealing with criminal law, which is either going to be, for instance, Ontario, the Ontario Court of Justice, or the Superior Court of Justice. Those are our two trial divisions in Ontario. And here's what this provision says, that when somebody is being sentenced, this is anybody, not just Indigenous, but non-Indigenous, just anybody, all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders. So that's the first part of it, which means that everybody, when they're being sentenced, basically that means that the very last resort for a sentence should be jail. And I'll get to the other part of the term, but that's what it says, with particular regard to Aboriginal offenders. So what it says is that all available sanctions other than imprisonment that are reasonable circumstances should be considered for all offenders. So everybody, Indigenous and non-Indigenous, the last thing that should happen is a sentence for jail, right? That's imprisonment, right? Which means, conditional sentences and probation and suspended sentences and fines, all the other kinds of sanctions that are available that don't mean custody, as in going to prison or jail, should be considered first. And then what this says really importantly is, not only should everybody, the last resort, be jail, but the last part of that sentence is, but with particular regard to Aboriginal offenders, it should be jail. All right. So not only should everybody not go to jail, in the first instance, the Aboriginal offenders should never go to jail in the first instance for the most part. That's what that kind of says. In 1996, that's what the criminal code said. And that was a direction to judges who, when you have a trial and there's a conviction, you go from being the trial judge to the sentencing judge, the same person. But the trial judge, deals with the verdict. The sentencing judge deals with the sentence. And this is the direction that was put in place in 1996, by the federal government under the criminal code, saying this: jail should be the last resort for everybody, and it should really be the last resort if you're Indigenous. All right. And that really didn't have much of an effect, even though it was the law of the land. But 3 years later, along came the case of Regina and Gladue, right, in the Supreme Court of Canada. And what this case basically said is that, they looked at, for the first time, that particular provision, 718.2 sub E, and they said, we recognize that the federal government had put that into the criminal code because of the absolute disastrous overrepresentation of Aboriginal Canadians in the criminal justice system. Just exactly what we all talked about at the beginning of this lecture, right? And so what they did is they said this was put there for a purpose. And the purpose is that when judges sentence Aboriginal offenders, right, they have to apply the principles of restorative justice alongside those of the traditional criminal justice process. So you guys already know what that is. So you know what this is the Supreme Court saying: when you have an original Aboriginal offender, look to restorative justice. That's what section 718 requires, right? And in doing so, the court, when it comes to sentencing, has to pay particular attention to the circumstances of Aboriginal offenders. They must look at the systemic discrimination that has existed, as even just being an Aboriginal offender, you're subject to, what's happened systemically over centuries that have led to this, this crime being committed. Must look at the socioeconomic conditions of their particular circumstances. Where do they live? Do were their parents abusive? Was alcohol and drugs, were they prevalent in their home? Those kind of things, right? And so what the court is saying in Gladue is when sentencing an Aboriginal offender, you have to consider those factors, and they have to consider whether imprisonment, would serve to deter or denounce the crime that has been committed in a meaningful way to the community in which the offender is a member. As in, would the offender's community, right, look at somebody going to jail as a meaningful punishment, right? And again, in a restorative justice context, it very rarely would be meaningful, right? Okay, now we're going to deal with Indigenous peoples and wrongful convictions. This takes us back to William Mullins Johnson in the video hopefully you all watched, right? Because we're going to deal with how wrongful convictions are dealt with in the Indigenous context, all right? And it's important to remember that wrongful convictions, and again, I teach a lot about this because this is my doctoral research. Wrongful convictions is the #1 recognized area for criminal justice reform in the world, right? Everybody recognizes, and this is, in the world meaning, and that includes China. That doesn't have to be a common law system, but it definitely includes all the common law systems, us, the United States, Australia, the United Kingdom, India, the systems that are common law, they recognize that. But I mean, other systems that, that like the European systems, the Napoleonic code, civil code systems like France and other parts of Europe and Germany, they recognize it as well. This is the #1 issue to be addressed because, and you understand this, there is nothing more important in criminal justice than ensuring that innocent people are not convicted and imprisoned. And the segue to that is that we know that thousands and thousands of people, in fact, are wrongly convicted and imprisoned. And so, there's nothing more important than getting innocent people out of prison, who should never be there, right? As a function of that, there's been a number of studies. Canada is very famous for doing public inquiries into this. The United States has done some work with integrity units. The United Kingdom has the Criminal Conviction Review Commission, which looks at this, and everybody agrees that there are identifiable systemic causes of wrongful convictions, things that are built into the criminal justice system that lead to, innocent people being convicted. And these are what they are: mistaken eyewitness identification, false confessions, tunnel vision by police, and Michelle mentioned that earlier, perjured testimony from jailhouse informants, Crown misconduct, usually that means lack of disclosure, which means the Crown doesn't turn over all the evidence to the defense, inadequate defense counsel, and faulty forensic science. And in the William Mullins Johnson case, you saw that it was, believe it or not, faulty forensic science that sent him to jail for 12 years in the prison, right? So those are the worldwide recognized causes of wrongful convictions. Not all of them really have a lot of application, particularly to Indigenous accused, but these 4 do: mistaken eyewitness ID, false confessions, tunnel vision, and inadequate defense counsel. All right. Again, even though William Mullins Johnson was faulty forensics, that wasn't particularly because he was Indigenous. It just happened to be a function of the pathologists that did their work. But these 4, do have identifiable issues that relate to, unfortunately, more Indigenous people being wrongly convicted than would be the norm. All right. And underlying those 4 are issues of race, poverty, substance abuse, and mental health issues. Right. So they all feed into those systemic causes. Right. The very first public inquiry into a wrongful conviction in Canada was the case of Donald Marshall Jr. I've mentioned him in previous classes. We've talked about him both with respect to criminal justice, and we talked about him when it came to treaty rights, because it was the same Donald Marshall Jr. who in Nova Scotia, he was the one that caught the 476 pounds of eels, right, and then sold them, was charged and convicted of selling out of season and not having a license, went to the Supreme Court of Canada, and it held in his favor that he had a treaty right. It was the Mi'kmaq people of Nova Scotia, a 1751-52 treaty that gave them the right to deal with what were called truck houses or trading posts at the time. And Supreme Court of Canada said that was an Indigenous right that allowed him to sell eels on a limited commercial basis, an incredibly important decision. Anyway, the same Donald Marshall, who also is the very first subject of a royal inquiry into a wrongful conviction, right? What happened was, very briefly, is that he was going through the park with a friend in Nova Scotia one night. A guy was stabbed and killed. It wasn't, Donald Marshall had nothing to do with it, but he happened to be in the group of people that it happened. The cops, when they came to investigate it, he was the only Indigenous one in the crowd. So they pointed their finger at him. Again, tunnel vision. Everything they did went toward the guilt of Donald Marshall, including them taking two teenage boys, 13, 14 years old, and basically forcing these teenage boys to testify that they saw Donald Marshall stab the victim. And it was only because, 15 years later, these young boys grew up into responsible men that they go back to the Crown and say, look, we were forced to testify against Donald Marshall. He wasn't the guy who stabbed the victim. It was Sandy Seal. So Donald Marshall did 15 years in prison for a crime he didn't commit. And what the Royal Inquiry basically said is that the criminal justice system failed him at every turn, from his arrest and wrongful conviction for murder in 71 up to including his acquittal in 83. So I'm sorry, it was not 15, it was 12 years that he was imprisoned. And it was compounded because not only was it the police that did it, the Crown did it, the judge, was highly prejudiced against Donald Marshall during the trial, right? And what the Royal Commission found is that, clearly this wrongful conviction was due, at least in part, but truly to a great degree, as a function of him being, at the term, native at the time. That's what he was called. And so the Royal Commission basically established recommendations to ensure a more equitable treatment of natives in the criminal justice system. Basically, it basically provided for training for Crown Counsel, judges, and lawyers, defense counsel. Okay. Further dealing with systemic causes. So let's deal with mistaken eyewitness ID. So this is the leading cause of wrongful convictions in the world. And that's because it's the most common way to convict an accused is by somebody at the scene ostensibly saying that they saw who committed the crime, and they stand up in a courtroom and they point to and you guys have seen this in movies and TV all the time. They point to the accused behind, in the courtroom and say, yes, that's who I saw shoot the gun, knife the, whatever the method of the homicide was. They identify the person in the courtroom, right? And in 80% of wrongful convictions, that identification was wrong. Matter of fact, it's notoriously a terrible way to convict somebody of a crime. The Innocence Project, you guys are probably familiar with the name of this. It was originally established at the Benjamin Cardozo School of Law in New York. Basically came up with a lot of research regarding mistaken ID, saying that the human mind is not like a tape recorder. People do not record events exactly as they see them, and they certainly don't recall them as if the tape had been rewound and then played in the courtroom. There is a big problem between recording an event, which is when you see it, and retelling the event, maybe 2 years later when you get to trial. Okay, there's a lot of things that can go wrong to change that. Now, when it comes to Indigenous persons, it's not just Indigenous persons, but it does apply in this case. Studies have shown that cross-racial eyewitness ID is a very difficult thing. All right, which basically essentially means that Caucasian witnesses have a harder time identifying an Aboriginal suspect than they do a Caucasian suspect, right? It could be, the same thing applies obviously to African Americans, it applies to Chinese, whatever is cross-racial that is non-white is more difficult. And it also applies between other races, as well. But, in Canada, it applies to white witnesses, Caucasian witnesses identifying Aboriginal accused, right? And what happens is that police often, have the availability to prejudice a eyewitness ID because they are the ones who constitute the lineup. Now, lineups used to always be, and again, you guys have seen this on TV movies, you see 12 guys behind, or 6 guys behind glass, and it's two-way mirror, and somebody's on this side of the mirror, and they identify them through that. That doesn't happen anymore. It's always done with photographs now, and there's ways to do it with photographs that are reliable, kind of thing. But there's a very famous case back in 1995 called Jason Hill. So Jason Hill, there was a number of robberies of corner stores like 7-Elevens, those kind of things, in Hamilton, Ontario, and the victims of these robberies, which are the people who ran the corner stores, for the most part identified the offender as being Indigenous or Aboriginal, right? So Jason Hill, who was Indigenous, he was on the radar of the Hamilton Wentworth police force. They knew him. He had a previous small record for some shoplifting, what have you. So they fingered him to be the offender, right? And what they did is they put him in a lineup. Now, this isn't his lineup. I just got this lineup from photos, but they put him in a lineup. There was 12 men, right? 11 of them were Caucasian or white, and he was the only Indigenous offender in the lineup. So when, obviously, when the victims, being the owners of the stores, came in to identify who's the guy that robbed you, and there's 11 white guys there and one Indigenous guy standing there, they remember the guy, the offender being Indigenous, right? And, the guy who had the darker skin, that's the guy. And that's how he was identified, right? He was eventually acquitted. He spent a little bit under 2 years in jail before he was acquitted. And he was only acquitted because these crimes kept taking place after he was in jail with the same MO. And as it turns out, the offenders weren't Indigenous, they were Latino, right? So anyway, having said all that, this says a lot about cross-racial IDs right there. So, he got out, he sued the police force for negligence. And it went again all the way to the Supreme Court of Canada. And, it was the first time that any court, any significant level of appeal court in the common law world created the tort of what's called negligent investigation. Canada is the only jurisdiction that has this tort, which basically means that police, right, can be liable for damages, right, for the lost wages or your time in jail, all those kind of things that would provide for payment if they do not conduct an investigation in a appropriate way. And so that's an incredibly important decision, right, around the world, essentially, for police accountability. Unfortunately, even though Jason Hill was successful in the Supreme Court in getting the court to agree that he had the right to sue the police for their negligence in that kind of lineup, the court said that back in 1995, and it reached the Supreme Court in 2007. So back in 1995, the court said, you know what, that wasn't, an entirely unlikely way for any police force to conduct a lineup. That was a pretty common way, in fact, for police to do that. And as a function of that, it wasn't negligent because it didn't fall below what's called the standard of care. So anyway, but it was an incredibly important decision. So eyewitness ID, again, works against Indigenous accused. False confessions, right? False confessions are the second most prevalent cause of wrongful convictions. 25% of all wrongful convictions are a function of a false confession. And it's pretty counterintuitive. I mean, why would you think, who would think that an innocent person would actually confess to a crime they've not committed, right? Well, as it turns out, a lot of people do. They do it for any number of reasons. The most prevalent reason, of course, is, and this is again highly recognized and written up in peer-reviewed journals, is that false confessions are the function of an abusive police interrogation. An interrogation, which will include duress, coercion. The accused could be intoxicated, could have a diminished capacity. It could be a mental impairment. There could be violence, an infliction of harm, the threat of a harsh sentence. All these kind of things. The police will coerce and use duress to get a confession, because nothing is more persuasive in a court of law to to basically find somebody guilty than a confession, even if that confession was retracted, almost immediately after it's given, right? If a jury hears that somebody confesses to a crime, right, doesn't matter whether, they were told, but he took it back right away, right? The mere fact that a jury is told that somebody confesses to a crime is the death nail in the case, right? Nobody believes, juries included, that anybody under any circumstances would confess to a crime they didn't commit, right? They don't care about the coercion that took place unless the defense can prove that there's been coercion. This result, and for Indigenous Canadians, the problem with this particular systemic cause is that it deals with what's called culture clash, which is undeniably a thesis that Aboriginal concepts of justice are different than Western society's concepts of justice. They're incredibly different. And the point of this is this, that in Aboriginal society, there's a great emphasis on taking responsibility for one's own actions, right? And in the criminal justice system, taking responsibility, can well lead to pleading guilty. But that's not what responsibility and guilt is all about. Being responsible for an event is not necessarily the same thing as being guilty of an event, right? That distinction is lost on Aboriginal offenders who take responsibility. So they may well plead guilty to offenses, which is a false confession if they in fact are not guilty because they have legally established offenses such as self-defense or diminished capacity. The European concept of guilty and not guilty runs counter to Aboriginal philosophy, right? Many Aboriginal societies do not in fact have words for guilty or not guilty. They're not concepts that have been developed in their languages. So that is lost on accused Aboriginal offenders. All right, false confessions and the plea deal, right? And this is a very common thing as well. So being denied bail often leads to an accused pleading guilty to end their time in jail without regard to being guilty or innocent, right? And you guys, again, are familiar with this because you will have seen it in TV and movies where, people will plead out, to the time that they've served waiting for trial, where, it will get them out of jail now rather than waiting for the trial and taking their chances, before a jury. It's the plea deal. So, if you're denied bail, and again, that Aboriginal accused are disproportionately denied bail to non-Indigenous accused for all the reasons we've already talked about. If they're denied bail and, they're sitting in court, and they've been there for 8 months or 9 months and the trial is still a year away, and their, defense counsel says, look, you're not, even if you went to trial, you wouldn't be sentenced to this kind of time, right? You might as well plead guilty now. Your time is served, get out, right? And you're going to save waiting in jail another year before you get to a trial where you may or may not be found guilty. It's always a crapshoot at trial. So, that happens a lot, right? So you've got people who actually plead guilty to offenses that they in fact are innocent of, and they know they're innocent of, but it gets them out of custody because, especially if you're an Indigenous accused, you've been denied bail and you're going to be waiting there until your trial. Here's some stats for this kind of thing. So Aboriginal charged persons are 1.34 times more likely, which is 55% to 41% to be held in pretrial detention. Adult males between 18 and 34 spend 1.5 times longer in pretrial detention, which means being denied bail, waiting for trial. Aboriginal women 18 to 34 are 2.4 times more likely to be held in pretrial custody, as in being denied bail, basically. And more people now spend time waiting for trial than due to sentencing after conviction, right? And this is a problem across the board. So bail has become a really serious issue in Canadian justice. And this is a graph I published in an article about 10 years ago, but here's what this says between 1982 and 2004. So the red dots, the red line with the round dots, and this is basically thousands. So in 1982, there were about, on average there were 118,000 sentenced inmates in custody, right? And if you see that, it goes continuously down to 2004, where it's around 60,000, right? At the same time, in 1982, there was only 48,000 inmates, in remand custody. We talked about what that is, right? Versus the 120 in sentence custody. Over the course of the ensuing 22 years, in 2004, there were 120,000 inmates in remand custody waiting for trial. You see what's happened? That's how difficult bail has become, right? And so it's virtually reverse their positions. There are 3 times as many people in remand custody that in sentence custody now. That's 2004, but it hasn't changed much. It's actually gotten worse than there ever was in 1982, right? And that's what this pie graph basically says, is that 2/3 of inmates in provincial programs, territorial and federal programs, are in remand custody waiting for something to happen, i.e. trial, whereas only 1/3 have actually been sentenced. And that's that's just not the way it should be. Okay. The next systemic cause is tunnel vision, all right? And again, Michelle related to this with William Mullins Johnson. The police play a critical role in almost all wrongful convictions. Now that number 1%, that was a number that was put forward by a professor named Marvin Zalman in about 2012. He's a professor at Wayne State University in Detroit. And he examined all the data that he could around the world on studies setting out how many people who are convicted are actually innocent. And this is the number he came up with. And that was called his best estimate. Now, about 2 years ago, that was updated by another couple of guys named Richard Leo and John Gould, who basically said that the better number now is between 3 and 5%. Okay, so 3% is now a pretty much accepted number. So 3% of people who are convicted in Canada, United States, UK, Australia, China, 3% who are actually convicted are actually factually innocent. They did not commit the crime. Either they weren't at the scene of the crime, or if they were at the scene of the crime, they did not do the crime itself, whatever the crime is. All right, so 3%. And that doesn't seem like a lot, but if you think about it, in Canada, in an average year, 200 to 240,000 people are convicted. And a lot of them, 95% of them, are plea deals where people plead guilty because they don't want to go to trial, and they're made offers that are basically said, look, if you take this offer, the sentence will be lighter than it will be if you go to trial and we get a conviction. You guys all have seen that as well. That's how the plea deal is. But having said that, 3%, let's use 3% as a number. So if 240,000 people a year are convicted, right? It doesn't matter whether it's a plea deal or they go to trial and they're convicted, 7,200 people a year who are absolutely irrevocably innocent of the crime of which they're charged are in fact convicted and, as it turns out, often put into prison, right? And you take that 7,200 and then you compound that every year because people's sentences go on and what have you. Tens of thousands of people in Canada right now are in prison wrongfully, right? You take that number in the United States, which has the largest number of imprisoned persons in the world. We imprison about 150 per 100,000 a year. They imprison 700 per 100,000 a year. So they essentially imprison 6 to 7 times more than we do. So if you use that 3% number with them, extrapolate that out times 10 times the population times 6 times 7 as a factor of convictions, and you're talking about hundreds of thousands of inmates are in prison in the United States wrongfully who are actually innocent. So that gives you the other number. The other number to keep in mind, even if it was only 1%, and this has actually been done in a peer-reviewed paper, even if it was only 1%, right? And trust me, if you're convicted of a crime and imprisoned, it's the end of your life as you know it. Your life will never be the same again. Everything changes. How people see you, how you're treated for employment, how relationships are with meeting new people, saying, oh, by the way, I'm a felon. It affects everything, right? So it destroys your life as you knew it. But think of it this way. If 1 out of every 100 airplanes fell out of the sky, and people lost their lives, obviously, as a function of that, their lives were destroyed. how soon before the air industry would come to a halt? It would almost be immediately, because who in their right mind would purchase a plane ticket to fly anywhere when they knew that the prospect of 1 out of every 100 planes would crash to the ground? Or, as we now know, 3 out of every 100 planes would crash to the ground, right? So just keep that in mind. That's how serious these kind of things become when you look at it in those terms. Okay, so again, many of the royal commissions that Canada's had, we've had 7 of them, found that police were subject to tunnel vision, which is here's what they do. They prematurely settle on a person as a suspect. They do not adequately explore other hypotheses or interpret ambiguous and even contradictory evidence as consistent with the accused's guilt. What's that mean? It means they pick somebody as the person they believe is guilty, and their vision goes down a tunnel towards them. Everything outside that tunnel becomes essentially irrelevant to them. Even exculpatory evidence that leads away from their guilt towards somebody else, they just ignore it because that doesn't fit their theory or their thesis that that person is in fact guilty. And once the police become convinced of a suspect's guilt, right, and become less likely to consider alternate scenarios that conflict with that guilt, it is almost impossible to turn away from that. It's almost impossible to not end up with a conviction, right? And that's because of that tunnel vision. Another element of police prejudice investigation is over-policing, right? So over-policing refers to the practice of police targeting people of a particular ethnic or racial backgrounds who live in particular neighborhoods. We talked about this with congregating in places where Indigenous peoples collect, right? Over-policing has led to a great deal of distrust of the police by Aboriginal people. Over-policing leads to police forming attitudes towards Indigenous peoples as violent, dangerous, and prone to criminal behavior. Trust me, that's the mindset of the Winnipeg Police Service, basically. It also leads to what's called overcharging, right? So according to provincial stats, 22% of Aboriginal persons appearing in provincial court faced 4 or more charges, compared to only 13% of non-Indigenous persons. At the other end of the scale, while 50% of non-Aboriginal charged persons faced only 1 charge, that was true for only 37% of Aboriginal persons, right? And the last systemic cause is inadequate defense counsel. So there was an inquiry done in the 1990s leading to what's called the Aboriginal Justice Inquiry. It found that Indigenous accused spent less time with their counsel and relied upon duty counsel more often than non-Aboriginal people, right? So they didn't, they spent less time with their lawyers, obviously, which doesn't lead to as effective a defense, and they relied upon duty counsel as opposed to having a privately retained counsel. Aboriginal accused were more likely than non-Aboriginal accused to appear in court without a lawyer, right? While 61% of Indigenous respondents saw their lawyers 3 or fewer times, 63% of non-Indigenous accused people saw their lawyers 4 or more times, right? 48% of Aboriginal accused spent less than an hour in total with their lawyers, compared to 46% of non-Indigenous peoples who saw their lawyers for 3 or more hours before trial, right? And this is important because the amount of time you spend with a lawyer preparing for trial can have significant consequences for how an accused is dealt with in the criminal justice process. Because a lawyer who spends less time with his or her client obviously is going to be less informed about the circumstances, is going to be less tuned into what the potential defenses may well be, right? And use or engage less resources available as alternatives to detention, right? Lastly, representation on juries. This is the last thing we're dealing with tonight. Okay, and we've touched upon this because we touched upon the Colton Boushie thing, which I'm going to give you a short video at the end of the class, right? But so the Aboriginal Justice Inquiry found that Aboriginal underrepresentation on a jury is a glaring example of systemic discrimination. Okay, and think about that. We're talking now about an accused Indigenous person, man or woman, coming before a jury and not seeing, a fair representation of Indigenous peoples on that jury, right? That's a fairly elementary concept. Of all the ways, this is what the Justice Inquiry found, that Aboriginal people are underrepresented in the system. This is the most disturbing, right? For names, and this is how we create juries, right? For names to be included on jury rolls that make up jury panels, right? Jury rolls is the vast number of names in a community. It could be the District of Algoma, it could be the District of Kenora, those kind of things. That's a jury roll. And then a jury panel is created, it selects a bunch of those particular, out of that roll, a panel of people who are potential members of a jury, right? And then that panel is summoned for jury duty, so you actually have to appear in court, for that jury selection process. All that is done in Ontario and most of Canada by the sheriff's office, right? So every county and district has a sheriff. So there is a sheriff for the District of Algoma who works out of 426 Queen Street, east or west, in the courthouse downtown in Sault Ste. Marie. The main reason Aboriginal people are not properly represented on jury panels is the way, in fact, the summons systems work, put in place by the sheriff's office, right? Because the sheriffs do not follow up on the summons being issued. And that leads to a decision in the Supreme Court of Canada called Regina and Concomitants in 2015. It was decided on May 21st of that year. And this was a decision as follows. So the accused, an Indigenous guy from First Nation Reserve, it was actually in Kenora, was charged with second-degree murder and convicted of manslaughter after a trial by a judge and jury. Prior to sentencing, the accused counsel learned, right, so this is after the trial, but prior to the sentence, that there may have been problems with the inclusion of Aboriginal on-reserve residents, this is from the First Nation outside of Kenora, who were on the jury roll for that district, where in fact he found out that there was difficulty in the sheriff getting in contact with the members of the First Nation, right? And then the sheriff didn't really actually follow up very well on ensuring that members of that First Nation were given a summons to come and be on the jury panel. It was obviously led to those people's not being available for the jury, right? At trial, this is before the sentence took place, the trial judge dismissed the arguments on that issue, and so that the accused lawyer appealed this one issue to the Ontario Court of Appeal. And fresh evidence was introduced on the appeal relating to the preparing of the jury rolls for the district. And what the Court of Appeal found is that the accused sections 11, D, and F charter rights, the right to a fair jury and due process, had been violated, and the Court of Appeal ordered a new trial. The Crown Counsel appealed that Ontario Court of Appeal decision to the Supreme Court of Canada, and the Supreme Court of Canada overturned the Court of Appeal and reinstated the conviction with the sentence that was put in place. The minority of the Supreme Court of Canada upheld the Court of Appeal decision, but of course it's the majority decision that becomes the law in that particular case. The majority held as follows. Representativeness is an important feature of our jury system. What is required is a representative cross-section of society, honestly and fairly chosen. With respect to the jury roll, representativeness focuses on the process used to compile it and not its ultimate composition. Okay, does everybody understand that? What the court is saying here in the competence was, yes, representation on a jury, racialized representation is important on a jury, right? But what's the most important part of that is that as long as the process to put it in place was done fairly or as properly as possible, that is what's important, and not the ultimate composition of the jury itself, meaning not the ultimate number of Indigenous peoples who actually sit on the jury, and obviously would create a representative cross-section, right? So the question becomes whether the state being the sheriff's office on behalf of the province of Ontario, provided a fair opportunity for a broad cross-section of society to participate in the jury process. And this is how that opportunity is defined. A fair opportunity will be provided when the state, again, the sheriff's office on behalf of the province of Ontario, makes reasonable efforts to, one, compile the jury roll using random selection from lists that draw from a broad cross-section of society, which means the sheriff for the District of Kenora took the jury panel, which is all the names of the people in the First Nation, people off the First Nation, off reserve, everybody that he could collect, basically, he would take that. So that would be a broad cross-section of society. And then, and the way it works is that it's not computerized, but it used to be in a drum with, you turn the drum and names come out of it, but now computerized. Jury notices, which means people actually choose for selection, are drawn from that broad cross-section. If the state, being the sheriff, makes reasonable efforts, but part of the population is excluded because it declines to participate, the state will nonetheless have met its constitutional obligation. And here's the real problem that exists. And this is a problem that is as much an Indigenous problem as anything else. One of the reasons why the sheriff could not distribute the summons for the jury on the First Nations and ensure they were going to take part in the process is that they refused, the members of the First Nation refused to pick them out of their mail, or they took them out of their mail and threw them in the garbage. Why would that be? Anybody? If you're a member of First Nation, why would you receive a jury notice in the mail and throw it in the garbage? Any ideas why? It's a pretty basic thing. They did it because they don't trust the Canadian criminal justice system. They don't have faith in a fair system for Indigenous Canadians. So they do not want to be our participant in that process, right? So that's a problem because that gives the sheriff an out. And the Supreme Court recognized that. If the sheriff made his best efforts to get the notices out there and to serve the summonses on the First Nations, and the First Nation peoples on reserve, obviously, throw them out, well, then he's done his job. And from a constitutional point of view under the charter, he's done a job sufficient enough so that the charter isn't breached in this regard, right? So as a function of that, the province was therefore not required to address the systemic problems contributing to the reluctance of these people to participate in the jury process. And that's another big problem. So, even though the Supreme Court, the majority of the court saw this problem, all they looked at is the sheriff's job to do it properly and did not look at the underlying social problems, leading to the fact that that people on the reserve did not want to participate, right? What the Supreme Court should have done is, looked at what had happened and said, but here's what you have to do to try to overcome that kind of alienation, because that's exactly what it is. And the minority in the Supreme Court recognized that. They held this, that the starting point is not the state's effort to comply, right, as in comply with a cross-section of getting the jury notices out there, but whether the jury roll was in fact representative, as in it's not the process that's important, it is actually the representation that's important. If the jury roll was not representative, the question should become whether the failure is attributable to the state, as in, is there something more the sheriff could have done? Of the factors that contributed to the unrepresentative jury roll, the list and the delivery of jury notices, these are the responsibility of the state. The state is paid to do this. This is what the sheriff is paid to do, is to ensure that there is a properly constituted jury, right? So the minority in the court is saying, we don't care how fair we think you have been in trying to do it. We don't care that, yeah, maybe you got the jury notices put into everybody's mailbox and, and you didn't, follow up that they were thrown out. The fact that you didn't follow up, tells us that you didn't do enough to ensure that the jury was properly representative with Aboriginal Canadians, right? The poor return rate of notices and Aboriginal disengagement from the criminal justice system were matters that the minority in the court said had to be addressed. That was the issue. And relying upon that, and these are terms you guys are now very familiar with, Ontario's efforts must be guided by the honor of the Crown, right? Ontario was required to consider the estrangement, alienation of Aboriginal peoples from the justice system, and to work with First Nations to fashion a solution to the problem, right? If Indigenous people are worried about and systemically worried about discrimination because juries are not properly representative of who they are, right? then it's the government's responsibility to ensure that they do not feel so alienated, so that they in fact will participate in those juries and therefore address the issue of representation. That's the way it should be, but that's not the way it is, right? The Supreme Court of Canada ruled against that finding. The minority agreed with it, majority didn't, right? And lastly, we have the case of Colton Boushie. So we've talked about this at some length in previous classes. And one of the group presentations is dealing with this case more specifically. But what I'm going to give you now is this is a video. This is the last video before we do the breakout questions. It's a short one. This only came out a couple of weeks ago. This is a RCMP watchdog which made a finding with respect to how poorly, we've talked about this before, how poorly the RCMP mishandled the Colton Boushie case.
Well, when a white farmer in Saskatchewan was acquitted in the murder of Colton Boushie, a young Indigenous man, it did spark cries of racism in the justice system. And there is now an independent RCMP watchdog report. It has concluded the police force did make mistakes during the investigation and also discriminated against Colton Boushie's mother. CBC News has obtained a copy of the findings. This is ahead of their official release on Monday. And our Bonnie Allen has the details in Regina.
Well, the Civilian Review and Complaints Commission is a national agency that reviews potential RCMP mistakes and misconduct. So it's completed 2 reports. One is into the police investigation of the shooting death of Colton Boushie. The other is into the police's treatment of the Boushie family. So I'll start with the police investigation. It made 47 findings, 25 of which it found no errors or misconduct. But in the other 22, it concluded there were operational mistakes. There were communications breakdowns. There were problems with securing the scene, protecting evidence, and dealing with witnesses. So for example, at the crime scene, police failed to protect the SUV that Colton Boushie was inside and thus lost blood-stained evidence. Now that was raised at the trial, and it was said that it did not affect the outcome of the case, but clearly a mistake and a problem. Another issue was how they interviewed witnesses. Police failed to direct Gerald Stanley and his wife and his son to not talk to each other before they gave their statement to police. Now, the commission found that police were justified in taking the other young people into custody for mischief, but how they were treated in custody was a problem because they were, of course, dealing with chaos and shock. They were potentially hungover because they had been drinking, and that those witnesses should have been dealt with much differently. Now, the investigation found that any gaps in the criminal investigation were not due to discrimination, but as you already said, the way they treated Colton Boushie's mother was discriminatory.
Okay, let's pick up on that point. What else did we hear regarding the police treatment of Colton Boushie's mother?
So after Colton Boushie was shot, police officers went to her trailer, surrounded it with 7 officers with their guns. They thought there was a witness inside, someone who had fled the scene, who may be armed and drunk. But when they went inside, they at the same time notified Debbie Baptiste that her son had died and searched her home, asked her if she had been drinking. The commission said they smelled her breath. They even checked inside her microwave to see if her story held up. Here's what Debbie Baptiste told us about that.
His food was in the microwave. And I was just like, I lied, and they went and checked the microwave and his food was in there. And I was thinking, what did I do wrong? Why are these cops doing this to us?
So the commission said that that was discriminatory on the basis of race. Now the RCMP has accepted that finding. Brenda Lucky, the commissioner of the RCMP, Brenda Lucky, says it was insensitive and it was discriminatory. The RCMP isn't going to make further comment on the reports at this time. But finally, some recommendations include cultural awareness training for all RCMP employees.
Bonnie, thank you for that. Or Bonnie Allen in Regina. Well, when a white farmer in Saskatchewan was acquitted.
All right, guys. Okay, so I'm now going to put you into the breakout rooms. So I'll send you there, and I will see you guys in about 10 minutes or so.